Hi everyone, welcome back to yet another episode of our channel, Law Point, and this is me, Preeti Elizabeth Jensen here. Our previous sessions were on bail. Today we are going to discuss about frequently asked question on this topic. We have Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to answer our queries. So our first question is, if an under-trial prisoner committed a non-bailable offence and is under judicial custody for several years, then is he entitled to be released on bail?
It was observed that many prisoners were languishing in jail for many years during investigation, inquiry, trial before a court passing judgment of acquittal or conviction. Time spent in jail was much more than the time they could have spent had the court found him guilty. So, to safeguard the right of prisoners, Section 167, Clause 2 of the Code of Criminal Procedure provides that if an accused person is arrested for the purpose of investigation in a non-bailable offence, he is entitled for bail if he is prepared to furnish bail bond, provided the police has not completed the investigation and has not filed the charge sheet even after 90 days of custody of this accused person. So, from the 91st day onwards, the accused person is entitled for bail. Apart from the statutory bail, where bail is granted on account of the default of the investigating officers to file the charge sheet or complete the investigation within 90 days of the arrest of the accused person, there is another provision under Section 436A of the Code of Criminal Procedure to protect the right of the prisoner. This provision applies where the person is arrested for a non-bailable offence by the police for the purpose of investigation. However, investigation is completed within the prescribed period of time. In this case, the person is in prison because the court has rejected his bail on multiple occasions. Here we have to see the duration of the sentence of imprisonment prescribed for the offence which he is alleged to have committed. If half of that sentence is over, then his lawyer can file application for bail for the release of the accused person on his personal bond with or without surety. However, if the public prosecutor object for the release of the accused person and justify for the detention of the accused person in prison during the time of trial, then the court may reject the bail application of the accused person. If that is not the case, the prisoner will be released on bail. However, after trial, after looking into the evidence, the court finds the accused person guilty of that particular offence, then he will be arrested again and he will have to undergo only the remaining period in jail, excluding the time he has already spent in the jail before completion of trial. For example, if a person is arrested for the offence of falsification of account, which is a non-bailable offence, if the public prosecutor object for the release of this accused person even after 3.5 years for sufficient reasons, then he may continue in prison. However, no person need to undergo imprisonment for a period more than what it has been prescribed for that offence. That means the person who is arrested for falsification of account has already undergone 7 years of imprisonment. Then he did not further undergo that imprisonment even if he has been convicted by the court for that particular offence.
Our next question is, what is the validity of anticipatory bail? That is, if a person has applied for anticipatory bail, then how long he can get protection from arrest?
The person who gets anticipatory bail gets protection from arrest till the court complete the trial. That means till the time the court convicts or acquits that accused person. The validity of anticipatory bail will not end just because the person is called by the police or summoned by the court. If due to special reasons or depending on the peculiar facts and circumstances of the case necessitating the court to limit the duration of the anticipatory bail, then court can do the same by limiting the validity of the anticipatory bail or by imposing special conditions.
Our next query is, for serious non-bailable offences like possession of drugs, sexual abuse of children, etc., is there any statutory restriction for granting bail?
We have seen that if a person is arrested for bailable offence, then he is entitled for bail. And we have also seen that if a person is arrested for non-bailable offence, then also he can get bail but at the discretion of the court. However, if any person is arrested under NDPS Act, that is Narcotic Drugs and Psychotropic Substance Act, or under POCSO Act, that is Protection of Children from Sexual Offences Act, then the court consider or review that offences very seriously and apply strict principles while deciding whether to grant bail or not.
Our last question is, what is bail bond and surety bond?
Bail bond is an important prerequisite or important condition for the grant of bail. Bail bond is actually an agreement promising the appearance of the accused person whenever he is called by the court, or an assurance to pay a certain amount fixed by the court or the police officer. Now, personal bond is executed by the accused person himself, assuring his appearance before the court as and when called by the court. On the other hand, surety bond is executed by a third party surety on behalf of the accused person, ensuring the appearance of the accused person whenever the court calls him. The third party surety must be a citizen of India and need to be an owner of any immovable property. This amount, which is deposited in court, can be received back once the court complete the trial and pass judgment in the matter, after deducting some administrative cost and other charges. If a minor is arrested for a particular offence, then for his bail he cannot execute a personal bond, because in the eye of law a minor cannot execute any agreement. Then for minor's bail there is only surety bond for his release. If in case the surety dies, or he makes an application before the court for discharging him from being a surety, then the court calls the accused person who is released on bail and direct him to furnish a fresh surety. If the accused fails to obtain or furnish sufficient sureties, then he can be rearrested by the police.
Thank you so much for watching our video. See you next week with another legal topic. Till then, bye.